What is a contested probate? Welcome to Frank Bruno Law. I am Frank Bruno. Sometimes I go forward, sometimes I go back. I've been discussing probate, so I think it's only fair to discuss a contested probate. So sometimes an heir, a beneficiary, the executor or proposed executor will come into conflict. There's a series of, there are different reasons for why there might be conflict. I'm only going to speak about the will contest in this video. So what is a will contest? And what is a contested probate? Well, contested probate is when there's the conflict, just very generally. And then a will contest is a specific type of conflict within the probate proceeding. That's when someone challenges the purported will. So the executor, proposed executor, has to bring forth the will to the surrogate's court in New York to determine the validity of the will. And someone from the outside says that will is not a legitimate document based on one of a few theories. The will was a forgery, just a fake will, or the signature was a forgery. The will was a fraudulent document. That's another one. Testamentary capacity. So this is where there's an allegation that at the time the will was signed, the testator, the maker of the will, the person in question, did not have the legal capacity, the mental acuity to sign the will. So that, in a nutshell, is a will contest. Now, should the person that alleges the will is not valid, should they win and no other will is brought forth, right? Hey, that's a fraudulent document, it's a forged document, here's the original will, right? That would be a scenario. But if there is no will and, no other will, and the proposed will gets thrown out, well, then there's no will to probate, and the matter must proceed in an intestate fashion, meaning no will, and the assets of the decedent will be distributed pursuant to the laws of intestacy. So if you have a will that you want to put forth to be probated, reach out to me. If a will has been submitted for probate and you think there was a problem with the will, a fraudulent document, a forgery, you think that at the time the will was created and signed, executed, that there was an issue with the decedent, well, it would have been the testator at that time. But if you think there was an issue of testamentary capacity, reach out to me. www.frankbrunolaw.com